Several times a question is asked regarding ombudsman, and that very office of ombudsman, the very institution of ombudsman, was first established in 1809 in Sweden, and an ombudsman is an officer of parliament, and his job was to ensure that the civil servants discharge their functions properly. The successful working of ombudsman led other Scandinavian countries to follow this suit. The remarkable impact of this institution and its incumbent in Denmark tempted conservative country Britain to institute ombudsman in England. The working of this institution in New Zealand and the United Kingdom has shown that it can fit in any system of government. Any fear that the ombudsman institution may not suit the needs of developing nation has been dispelled by Tanzania. The Tanzanian Ombudsman is a permanent commission of inquiry, and it was established in 1965. So, usually the ombudsman is a lawyer, professor, or judges who has no political or financial acts to grant. He is highly paid and elected for a term of certain years. The literal meaning of ombudsman is a delegate or agent. So, the very term ombudsman refers only to institutions which has the basic and unique characteristics such as the ombudsman is an independent and non-partial officer of the legislature who supervises the administration. So he deals with specific complaints from the public against administrative injustice and maladministration, or he has the power to investigate, criticize, and report back to the legislative, but not to the reverse the administrative action. He submits a detailed annual report to the parliament, and he sets out the reactions of the people against the government, their complaints against it, together with his recommendations for eliminating the causes for complaints. One important safeguard is that his decisions are published in the press. For instance, the ombudsman reprimands the policeman. The news appear in papers and the readers cheer. Thus he is a most popular personality, and he becomes more so because he can interfere even in matters which are not investigated by the police. So, ombudsman may require into both types of complaints, intensive and instructive, and indicates how, in his judgment, he provides justice to the people. For instance, one day some dancer voiced a grievance against a ballet instructor. An army officer complained that he was not promoted in his storm. The ombudsman once called to account the foreign office and the Ministry of Finance for permitting a former diplomat to misappropriate public funds. A doctor who had refused to attend on a sick man and a civil service commission who had put improper questions to the candidates were also dealt with by the ombudsman. It is therefore said not without justification that the ombudsman opposed protection to the individual citizens against the vast impersonal despotism of modern democratic government. The authority of ombudsman extends to the police, the armed forces, the personal houses, the hospitals and mental health authorities and to whole of the civil service. However, such institutions which are exempted from the very cognizance of ombudsman are the parliament, the law courts and autonomous local councils. So this is how the very institution of ombudsman developed in Sweden and how it spreaded to other Scandinavian countries, also to New Zealand and United Kingdom, and how in developing countries like Tanzania, so also in case of other developing countries including India, how it been developed and how ombudsman now is a very integral part of our banking and insurance industries which are developing day by day. So in that connection of ombudsman, we would discuss the very institution of ombudsman in India in the form of Lokayut and Lokpal. So in our next answer, we'll discuss how in India it developed. In case of India, there is a paramount need of a powerful institution similar to that of an ombudsman to check the growth of administrative lawlessness and corruption, which is eating into the very vitals of the nation. In 1968, the Indian Union Cabinet decided to appoint an ombudsman type of functionary to be known as Lokpal to inquire into allegation of corruption and maladministration against central ministers and secretaries in union government. It also decided to bring forward necessary legislation for the purpose. Prior to it, the Prevention of Corruption Act 1947 was one among the other measures. But this measure failed, and on the recommendation of the Santanamam Committee, the Central Vigilance Commission was established in 1964. But all such measures have not been able to check menaces of every increasing corruption. So the idea of ombudsman was first suggested by late Mr. N.C. Sitalbad in 1962. This was taken to the parliament by Dr. L.M. Singhvi, then a member of parliament, and received nearly full support there. The Administrative Reform Commission in 1966 fully examined this idea and supported an institution of ombudsman. So Lokpal used to be appointed by the President of India after consultation with Chief Justice of India, the Chairman of the Council of States and the Speaker of the House of Peoples, the presiding officers of the Parliament, before expressing their views, may consult the leaders of various parties or groups in the houses. No such consultation is required by the Chief Justice of India. Under the 1977 bill, the Lokpal was to be appointed by President after consultation with Chief Justice of India and the leaders of opposition in House of People, or in absence of a leader of opposition, a person elected by members of opposition. The bill does not positively lay down any qualification for the appointment of office of Lokpal. However, it lays down that he shall not be a member of parliament or state legislature, should not hold any office of profit or trust, should not be related to any political party, etc. So, the very Lokpal bill, which was brought in 1977, as it was introduced in Lok Sabha, it was referred to a joint committee of parliament, and the committee submitted its report in 1978, and after that, as the Lok Sabha was dissolved in 1979, so the scope of the bill remained inconclusive, but the government, as under the bill of 1977, as the skeleton of the bill was prepared, and the bill of 1989 is more or less same as this previous bill of 1977. So, in the very subject of Ombudsman, the very institution of Lokayut was the very birth of an ombudsman is the center, is still doubtful, but many of the states in India, they have appointed Lokayut. So, in Odisha, as in case of 1970, there was no appointment, but Justice E.S. Katwala was appointed in 1972, and regarding Maharashtra, Justice A.R. Simpy, who resigned in 1979, in his place Justice N.D. Kamath was appointed in 1979. And in Bihar, in 1973, Dr. S.B. Soni, then and retired ICS, was appointed as Lokayut. Also in Rajasthan, in the year 1973, Justice I.D. Dua, and then later in 1978, Justice D.P. Gupta, also in 1975 in Uttar Pradesh, Justice Dishambar Dayal, and in 1975 in Madhya Pradesh. And in this way, some states they appointed Lokayuts, and regarding the very working of Lokayuts, the ombudsman strategy has been developed in various states and has not been designed to cure the whole spectrum of administrative faults. Lokayuts have been denied jurisdiction over ex-ministers and ex-secretaries as provided under certain acts as enacted as per the UP Act or the Bihar Act or the Maharashtra Act and even the Rajasthan Act. So, this Lok Acts sometimes there is also a limitation that the identity of a public servant affected by the investigation cannot be disclosed to the public even after investigation, as we found under the Maharashtra Act, and such as this seems to be no valid reason for this prohibition when a public servant has been found guilty. So, jurisdiction has also been excluded if the servant has been complainant has or had any remedy by way of proceedings before any court or tribunal. So, this constraint is also not desirable when the majority of grievances of public servants arise from different sources. Lokayuts have also been generally handicapped in the proper discharge of their functions due to the absence of any investigating agencies, as we found in the very Bihar and Maharashtra report regarding the very functioning of Lokayuts. So, as a result of this, big fish either escape the net or casting of the net around them is inordinately delayed. So, the working of the Lokayuts in the state shows that they can easily be fitted in the constitutional structurization of India and can perform their duties efficiently if the cooperation of ministers and public servants is assured. In spite of these formal or informal constraints, it is true, but nevertheless true, that the selection of a right person for this important position is itself the most important safeguard against administrative abuse and inefficiency. So, the very relevant question regarding Ombudsman and Lokayut, as in case of India, we discussed the very institution of Ombudsman, how it's originated, and the very growth and development of Ombudsman, and how it was incorporated to Indian judicial system, and how the very provisions regarding the Lokpal and Lokayut has been under the 1977 Lokpal Bill and again the Refund Bill in 1989 and the very appointment of some Lokayuks in the various states such as UP, Bihar, Maharashtra, etc. And as per the limitations on the function of Lokayuks, we already discussed all over these aspects in this particular question, which many times asked in various exams, whether it is 5 year or 3 year LLB exams or even in judicial service examinations.